Hello, everyone. My name is Kate Zyla. I'm the Executive Director of the Georgetown Climate Center, and I'm really thrilled to welcome everyone to this webinar today. For those of you who don't know, the Georgetown Climate Center, we are a nonpartisan law and policy research center based at Georgetown University Law Center in Washington, D.C. And we were launched in 2009 to help support and connect the work of state and federal policymakers working on climate change and energy issues. I'm really excited to welcome you all to today's webinar exploring the implications of the Supreme Court's decision in the West Virginia versus EPA case issued last Thursday on the final day of the court's term. We have a really terrific panel of Clean Air Act legal experts for you today, and also a very large audience registered for the event that I'm very excited about and see the number still ticking up as we go, so people are still joining. Before I introduce our fabulous moderator, Professor Sheila Foster, I want to provide a little bit of technical details on how this webinar will proceed. The audience will be muted throughout the entire webinar. If you have any questions for the panel, please put the question into the Q&A with the little Q&A button you'll see at the bottom of your screen. Given the size of this audience, we'll have to be a bit judicious about the questions we put to the panel, so we'll be collecting those. The Climate Center team will be collecting those as they come in and providing them to the moderator. We'll try to combine questions that are similar and potentially rephrase a bit to cover as many of those questions as we can. With apologies if we can't get to all of the questions, we will do our best. The webinar is being recorded and will be posted on the Georgetown Climate Center and Georgetown Law websites afterwards. And with those logistical details, we'll get straight to it. And I would really love to introduce you all to Professor Sheila Foster, who will be moderating the panel today. Thank you, Sheila. Thank you. Actually, I should say a few words about you first before I do that. So Sheila is Professor of Law and Public Policy at Georgetown. She's also just completed service as Georgetown Law's inaugural Associate Dean for Diversity, Equity, and Inclusion. Before coming to Georgetown, she was a professor at Fordham University and before that at Rutgers. And Sheila, I hand it off to you to get us into the meat of the conversation today. Thank you so much for joining us.
Thank you, Kate. It's a pleasure to be with all of you today and also with this very distinguished panel. I'm going to briefly introduce all five of our panelists and ask them each to give short remarks about the decision. And again, a brief introduction if you want to know more about the speakers and their perspectives on issues regarding environmental law and climate regulation. Their long and remarkable resumes are just a Google search away. Our first speaker is Jonathan Adler, a professor of law at Case Western University, where he founded the Center for Environmental Law and teaches courses on environmental, administrative, and constitutional law. Our second speaker will be Bill Busby, a professor here at Georgetown Law and who also serves as the faculty director of the Environmental Law and Policy Program. Next will be Kirti Datla, who is a director of strategic legal advocacy for Earthjustice here in Washington. Prior to joining Earthjustice, she worked in the Supreme Court and appellate practice group at Hogan Lovells. Lisa Heinderling will follow her. She's a professor here also at Georgetown Law, where her focus has been on environmental and administrative law. She also served for 2 years in the Obama administration's EPA, including a stint as associate administrator for policy. And last but not least will be Jeff Homestead, who leads the environmental strategies group at Bracewell. Jeff served for 4 years as the assistant administrator for air and radiation at EPA under the George W. Bush administration. So let me turn it over to Professor Adler.
Great. Well, first, let me say it's a pleasure to be here virtually with all of you today to talk about what is, I think, clearly the most important administrative law and environmental law case of the just completed Supreme Court term. I want to make a few points very briefly and then turn it over to my co-panelists. First, as to start, I think it is important to recognize that this is an important case that has broad implications beyond environmental policy, and I want to say a little bit about why that is. In terms of kind of understanding what the court's bottom line conclusion was, I think the court underlined and put an exclamation point on the principle it had made clear in the OSHA COVID vaccination or mask policy decision, NFIB versus OSHA earlier this year, which is that federal courts should be very wary when federal agencies seek to pour new wine out of old bottles. That is to say, when a federal agency takes a statute that may have been last enacted or reauthorized or amended years ago and seeks to use provisions in that statute to address a new or contemporary problem, to address something that it had not addressed before, or to do something in a way that it had not done before, courts are going to be skeptical of that. That using old authority to deal with new problems raises a question because the courts can't be sure that this is something that Congress actually delegated the agency the power to do. And that's important because, as I think the majority opinion makes clear, agencies only have that power that Congress has given to them. And it's one thing when Congress enacts a broad statute it's one thing to expect the agency to fill in the details, to smooth off the rough edges, to clarify things or make sure the pieces work together. It's quite something different for the agency to seek to repurpose that statute, to redirect it, or to do something that had not been anticipated or foreseen by the enacting Congress. In effect, if Congress gives the agency a wrench, the agency has a wrench. And if the agency decides what it would be really useful to have as a hammer, well, we may be aware that if you take a wrench and you're careful, maybe if you hold it on its side and aim very carefully, you might be able to drive a nail with it. A wrench is a wrench, is a hammer, and a hammer is a hammer. And if what the agency wants is a hammer, I think Chief Justice Roberts' opinion makes clear the agency needs to be able to identify evidence that Congress, in fact, gave a hammer. That it's not enough that the language might be sufficiently broad or capacious to imagine a hammer, but that Congress, in fact, delegated that authority. In terms of how to understand this, it's also important to understand that the majority opinion, at least in my view, doesn't ultimately rest this on non-delegation concerns. There's a separate concurrence by Justice Gorsuch, which is certainly motivated by non-delegation concerns that there are limits to what Congress actually can delegate to an agency. Only one other justice joined that opinion. Rather, I think the Chief Justice's opinion suggests this is something in terms of how, something fundamental about how courts should evaluate agency claims to have powers that they have not previously exercised, and the need for the agency to be able to identify a clear authority for that. The other thing that I think is significant about what Chief Justice Roberts did and could have significant ramifications going forward, and I'll close with this point, is Chief Justice Roberts, much like in his dissent in a case called City of Arlington versus FCC, makes clear that this concern about showing clear warrant, clear authority in the statute for a major exercise of power is something the court should look at up front. This is not a tiebreaker at the end. This is not something to simply resolve an ambiguity. This is rather something that should be on the table when the court begins its statutory analysis. And I think that's significant because I think it creates a much broader opportunity for litigants to try and invoke this theory. I think it gives courts more flexibility in terms of when to consider whether something is a major question. I think we may get into, I think there are other ways the majority might have done this that would have been doctrinally more constrained. So I think it is significant that the way that Chief Justice Roberts chose to write this opinion, and as he foreshadowed at oral argument, is that this concern about needing clear warrant for agency authority, if there is something we think is extraordinary or major, is something you do up front. And I will stop there. Thank you.
Thank you, Professor Adler. Let me bring up Professor Busby.
Okay, so hi, everyone. So first, thanks to Kate Zyla and Georgetown's Climate Center for hosting this webinar, and then also to the fellow panelists. I'll kind of break my very brief comments to three categories. Very briefly, the merits of the decision. Second, climate next steps. And then a little bit what Jonathan just talked about, a little about the major questions doctrine, because I think others will cover that more. On the merits, I think that the criticisms are appropriate. Jonathan was more praising it. I think this is a problematic methodological mess that did violence to the Clean Air Act and even the court's own precedents. There's a big issue. Should the court have taken it? The court has erected major hurdles to standing and getting into court in past cases. They kind of waved this one through. That itself is a problem. If we hope the Supreme Court will be neutral, a neutral arbiter, it certainly is not that. What we really have here is an advisory opinion on a never effective rule that was based on the Supreme Court's cherry-picked mix of hypothesized or projected impacts, even when some of them have been proven wrong, and the court knows it, and Justice Kagan pointed that out in her dissent. The court also really does a terrible job at just a statutory interpretation. It wouldn't do well in a class on legislation and regulation. There's a link between Section 111D and Section 110 that is expressed in the statute that is kind of using SIP-based strategies for 111D. That's the provision-based regulation. The court refers to it, doesn't seem to be aware that that express reference is there. And then a major problem is the court belittles the actual term as a backwater or empty vessel, when in fact this is a major provision that is the way you regulate major categories of stationary sources. And so I think it's a terrible decision on the merits, but we're stuck with it now. So then the question is, what next? What are the next climate steps? It could have been worse. So first, importantly, the court really just addressed EPA's action devising this generation shifting strategy under this provision. It did not question EPA's power to regulate under this provision. That remains intact. That's important. It is a kind of narrow decision. Second, stationary sources, power plants are not the only greenhouse gas emitters. There's nothing in the decision to question EPA's power to address climate change through other provisions. The parties didn't push for that, but some of the amicus briefs by others did make that argument. The court did not go there. Similarly, I think the way the court approached this actually should be favorable for regulation in the transportation sector, where the court looks so much at, is the agency regulating as it has in the past or in similar ways? And so I think here that's this case is not terrible for the other major category of greenhouse gas emissions. Another few important things left standing. The court didn't do anything to undercut polluters and states' compliance flexibility. This is something that the Trump administration and coal allies had pushed against. They wanted to say that both in setting emission limits and also in devising compliance strategies, everyone should look only so-called inside the fence line. And the court did not go there. That's very important. That means people can look for cost-effective ways to comply, and that pushes things in a slightly, I'd say, progressive, cleaner energy direction. The court didn't question states' abilities to regulate more stringently. It would have been hard to do that, but the court didn't do anything to question that. And so I think that's very important. Now, broader implications, my last couple minutes. This is a huge separation of powers decision. This really is just a major arrogation of power by the Supreme Court to itself and to the courts, undercutting the power of Congress to set policy and undercutting the power of agencies to do as Congress instructs. I think this is a terrible problem. And there's a couple things. So, what you really have now is agencies that want to address new problems, as Jonathan talked about. The court automatically is skeptical of national regulations where agencies address a new problem. That's always the nature of national regulation. Agencies step in to address a problem that hasn't been handled. So the whole frame of the major questions doctrine is a major problem. And similarly, the court repeatedly says Congress had to be more clear and more specific. Well, the problem there is that agencies often need flexibility, so you don't want to have very particularized language. And then second, to pass laws, compromise is often needed. And so sometimes broader language is a way for Congress to pass laws that are needed. And so the court sort of hamstrings agencies and actually makes it hard for Congress. I think, here a problem that I hope we'll get to some is the court talks about this as an extraordinary action with huge economic and political impacts. But actually, under the facts, that wasn't the case. That in the DC Circuit litigation over the Clean Power Plan, when asked by, as I recall, Judge Srinivasan, who asked a question to the lawyer for the coal interest, said, show us what's wrong. Where do they get something wrong about what's being done on the ground by the best power plants as emissions reductions? The person questioned pointed to a single table and said a number was wrong. They really had nothing. And then time showed that these were not aggressive targets, so they weren't aggressive. With no regulation, the emission targets were surpassed. And the court nonetheless keeps talking about this as being huge overreach with major impacts. It's really major exaggerations. And the court doesn't force people to show the empirical basis for their claims. This is also long-term a problem. If the court is going to just take exaggerations and find that to be enough, then all regulation is vulnerable. What can you do? Other than changing the court, you could strip the court of some jurisdiction, and something that actually Professor Heinzerling and I have talked about in previous panels here at the DC Bar. Agencies could do more things with on-the-record process that would test claimants' allegations of huge impacts, and that might weed out the wheat from the chaff, that is, force people to really ante up and show problems. Maybe that could change these kinds of arguments. I'll stop there and leave it to others.
Thank you, Professor Busby. Okay, over to Kirti Dalla.
Thanks, Professor Foster, and thank you to Georgetown for having me. Like Bill, I think I'm going to try and quickly make 3 points. The first is that while I can't claim to see into the minds of the Chief Justice or the rest of the members of the majority, I think that one thing they were trying to do in this opinion is provide some clarity on what the major questions doctrine is. And I think that was an important goal because, there might be some disagreement about this on the panel, but what the court is doing in this opinion is taking, precedents that were decided in different contexts. For example, precedents that were decided in the context of whether or not to apply Chevron deference, or taking, to use the court's word, sort of ancillary statements and prior decisions, and weaving them together into this doctrine. And so, when it's engaged in that kind of project, it needs to provide some sort of clarity. And I think if that's what the court's goal was, or at least one of the court's goals was, I don't think it succeeded. So by my count, the court provided 7 factors that might trigger the application of the major questions doctrine. And I agree with Professor Adler that the court is clear about how it functions, which is it's the first thing you ask, does the major questions doctrine apply? And everything else is sort of secondary. And some of those factors track the old wine bottles theory that Professor Adler offered, and some don't. Some are things like, is it ancillary? Some are whether Congress has attempted to do this, it failed, and so it doesn't kind of neatly fit any theory of what the major questions doctrine is. And the majority doesn't provide any sort of test as to what might be adequate to overcome it. And one thing that's sort of striking is that if you put the majority's test as to the 2 steps, does it apply, is it overcome, next to the concurrences, the factors that the majority thinks are relevant to whether the major questions doctrine applies are the same factors that 2 members of the concurrence who joined the majority say is evidence that the level of clarity needed to overcome the major questions doctrine hasn't been met. So at least 2 members of the court are kind of getting the agency coming and going. And so what I think that means is that it's hard to imagine a case where when this doctrine applies, the agency will be able to overcome the kind of clear statement rule that's being put forth in this case. And that has all sorts of important implications, many of which Bill has already run through. The second thing I think is worth thinking about is the upshot of Justice Gorsuch's concurrence, which was joined only by Justice Alito. Those are 2 important members of this new majority on the court. And one notable thing to flag is that Justice Gorsuch says one of the reasons the major questions doctrine is important is because it prevents sort of swings in policy, he uses the word law, but swings and rules from one administration to another. And he kind of suggests that that's anti-democratic. And if you're familiar with another line of the court's cases involving presidential control over the heads of agencies and other agency actors, cases like Free Enterprise Fund, the court says the reason that presidential control is important is precisely so the president can impose his or her priorities on the agency's actions. And so if you want to think about how to reconcile those two lines of precedent and how to think about how could Justice Gorsuch not being inconsistent there, I think the answer is, and it's not a surprise, he's been very clear about this, that, the administrative state in his mind should be, a set of agencies carrying out very limited duties that are so detail-oriented that they wouldn't shift from one president to the other. And I think it's important to know that that is what two, maybe more members of the court currently think the administrative state should look like, because that is not, as Justice Kagan's dissent points out, what the administrative state currently looks like. And speaking of dissent, I think the third point that struck me is the sort of lamenting tone of Justice Kagan's dissent and her emphasis on how, I think she has been engaged in this project of really engaging with the idea that textualism is the kind of highest and best form of statutory interpretation, taking it seriously, trying to work out its contours. And again, I can't afford to speak for Justice Kagan, but it does have the feel of her kind of saying, I was, almost tricked into buying into this project, and the rug has been pulled out from under me. And so I think, that tone in her dissent is somewhat unusual for her and is something that stood out to me.
Wonderful, perfect timing. Professor Heinzelman.
Hello, everybody. Thanks for holding this panel and for inviting me to it. There's a lot of commentary on West Virginia versus EPA in regard to EPA's authority. And I know some people have already mentioned its effect on congressional power, but I just want to really highlight that point. I think the most dangerous aspect of the court's decision actually is the court's seizure of power from Congress, not from the agency. Under the opinion, Congress may no longer enlist an agency's help in addressing major issues, as it's done throughout U.S. history, unless it speaks clearly enough for a hostile Supreme Court to hear it. It's perverse. Congress is limiting in acting on the very problems that are the most important to us. And Congress itself will need to, in enacting legislation, employ what Kirti just called the 7-factor test the Supreme Court announced in this case in figuring out how clear it has to be and how clearly it has to scrub a statute for any sign of ambiguity on major issues. So the majority hints on this point about congressional power. It hints that the Congress has two options going forward. One, it can make the major policy decisions itself, or two, it can give clear congressional authorization to an agency to regulate in a particular manner. In fact, I don't think this is actually a real choice. First, on the first option, what would it look like for Congress to make the policy decision itself? And let's talk specifically with respect to the role of generation shifting in setting emission limits under Section 111. I think only if Congress clearly requires generation shifting does it make the policy decision on generation shifting itself. In that case, it would leave it to EPA to fill out the details of the regulatory program and to enforce it. And so there'd be no problem from the major questions perspective. It would have made the major decision itself. But suppose Congress follows that supposed second option and says, well, we're going to clearly authorize generation shifting, but we're not going to require it. We're going to leave that choice to EPA. We say you can do this or not as you see fit. If Congress does that, it actually hasn't answered the major question the court wants it to answer before EPA may regulate. And in fact, it's clearly and deliberately not answered the major question the court identified. So the question is that really a choice that Congress can make at this point? Would that be okay with this Supreme Court? Should we take comfort that the court seemingly left a second path open to Congress? I don't think so. I think the court would say that such a statute does clearly authorize EPA to decide a major question, whether to embrace generation shifting, and thus it gets past the clarity requirement embraced in West Virginia. But I think that would just take the regulatory action out of the statutory frying pan, so to speak, and hurl it into the constitutional fire. I think the court would go on in that case. And again, remember the situation in front of us. Suppose Congress said, your choice, EPA, we're fine with generation shifting, but you tell us, you make the call. I think the court would go on to say for that reason, because the statute gives the EPA the authority to answer a major policy decision, the statute actually violates the non-delegation doctrine. This is what Justice Gorsuch said in his dissent in Gundy versus United States a couple of years ago. That's the opinion that Chief Justice Roberts and Justice Thomas joined in that case. I think this is actually what follows from the rhetoric and reasoning of the opinions in West Virginia. Justice Kavanaugh has actually said this much in a statement on the denial of certiorari in a case called Paul versus United States. He said that the opinion of Justice Gorsuch and Gundy would not allow Congress to pass off a major decision to an agency, even if it really clearly, in crystalline terms, passed off that decision to an agency. So for my purposes, I take zero comfort in the fact that Justice Gorsuch concurred separately in West Virginia and that he was only joined by Justice Alito. I think the majority in concurrence in this case are saying exactly the same thing, and I think they're using the same test. Only Justice Gorsuch, of course, says that this test is constitutionally inflected. He says it's inflected with the non-delegation principle. Chief Justice Roberts doesn't make this as clear, but he does refer to separation of powers principles undergirding this doctrine, and that those principles here, of course, are the non-delegation principle. So all that to say is I think that this case is fundamentally, directly about an attack on congressional power. And I'll just say, and maybe I can discuss this more further later, but I think there's a tell in Roberts' opinion on this point. He doesn't cite his own major questions opinion, King versus Burwell, in talking about the precedents on major questions. He doesn't refer to it in the long catalog of cases. And I think it's because in that case, he actually left the power the agency had exercised in place at the end of the case. The federal subsidies remained available on federal exchanges under the Affordable Care Act. So that case gave Congress power that West Virginia declines to give to Congress. And it seems to me that's a telling clue about this decision's impact on Congress. Thanks.
Thank you, Professor Heindlen. And Mr. Homestead.
Thank you. I'm glad to have the chance to be here. There's much I'd like to respond to, but I think it probably makes more sense for me as someone who has worked at EPA to talk more generally about what I think this leaves open for the agency. First, I think I agree with all the panelists that this is an enormously important case when it comes to administrative law. I think that ultimately in terms of sort of the current debate over climate change, I think it could end up being important for the SEC in terms of its efforts to mandate additional disclosures regarding greenhouse gas emissions. Maybe it could impact what FERC is trying to do with natural gas pipelines. But ultimately, I don't think it will have a significant impact on how EPA approaches this issue. And let me explain why. I've made my career working at and watching EPA. I keep in touch with what the agency is thinking on a variety of issues. I don't think that the political appointees or the career appointees had any interest in pursuing something like the Clean Power Plan. And again, had there been a different Supreme Court, they may well have tried that. But I think long before this decision, there was an understanding that the Clean Power Plan likely wouldn't fly. So I don't think the Biden EPA was planning to pursue this kind of an approach anyway. If anything, it actually gives them more flexibility than I think they thought they had. As several of the panelists have mentioned, they specifically declined to endorse the view that it was only measures that could be taken at a particular source. They spoke approvingly of trading. They talked about the flexibility that states have in terms of meeting any Section 111D emission guideline or limitations that EPA may set. And I think those two things actually give EPA more flexibility than they thought it had. But I'd like to just take a step back and talk sort of more generally about EPA's regulatory authority to deal with climate change. I think it's quite clear, as other panelists have said, that EPA does have the regulatory authority it needs to deal with the transportation sector. I think it needs to be cautious about that. I think if they mandated the elimination of internal combustion engines in 5 years, that might be problematic. But EPA has taken a much more gradualist approach by reducing the greenhouse gas emission standard. And so I think that authority, I think they have plenty of authority in that case. They have plenty of authority to deal with methane emissions and emissions of other high GWP gases. The kinds of things they're talking about doing for the oil and gas sector are clearly within what EPA has historically done. They could regulate emissions from the farm sector under the Clean Air Act. I don't think they will for political reasons. But when it comes to methane and other high GWP gases, I think they have the regulatory authority that they need. But I think EPA's authority under the Clean Air Act to deal with industrial sources of CO2 was problematic before this decision and is equally problematic afterwards. Even if the court were to have endorsed sort of generation shifting as a strategy under 111D, that certainly is a strategy that could reduce CO2 emissions from the power sector. But if you look at all the other industrial sectors, there's no other analogy for this. There's not some way that EPA can gradually shift production of cement or iron and steel to newer, cleaner plants. It's a technological problem. It's not a regulatory problem. And I don't think, beyond the power sector, EPA had really ever developed an effective way to do regulations of industrial sources. I say all of that in part because I do think we need to look not only to Congress, but all the other things that are going on throughout the society, that's going on in the states. I've often observed that when the Clean Power Plan was adopted, the administration made it clear that that was the centerpiece of its program. There was much discussion about how that was the key to reducing CO2 emissions in the United States. It was the big thing. Ultimately, that was struck down, and here we are 7 years later, and emissions from the power sector are well below what they were required to be under the Clean Power Plan. So ultimately, I don't think the answer for all the questions that we face with climate change are necessarily regulatory. Finally, I think I have 1 more minute. I do think when it comes to EPA regulation that this case really knocks out a lot of the more creative ideas that people have developed, including a number of academics. I think they've come up with textually plausible ways that EPA could regulate CO2 under Section 115 as a criteria pollutant, as a HAP, that it could be regulated under TSCA. And I think all of those sort of creative new wine in old bottles ideas are probably out the door, but I don't think EPA was planning on pursuing any of those anyway.
Thank you very much. Lots to follow up on. So I want to first ask the panel if they would like to respond to or reflect on what the other panelists said. And I'll ask you to raise your hand in doing so. And as a reminder to the audience that you can put questions in the Q&A box on Zoom. We'll get to audience questions shortly. Professor Busby.
Just a question I have that kind of inspired in part by Lisa's take, which is a lot like mine, that this is a big issue for impairing congressional power and putting Congress sort of in a difficult position. I'm looking at this provision, it's a classic benchmarking form of regulation, which is all over environmental law and risk regulation statutes, where the constraint on the agency is looking at the world based on some criteria and a set of targets it has to analyze, and then responding based on what it finds empirically. So the constraint is the data, the science, the on-the-ground track record that they find. And so I've always viewed that as actually very constraining, right? That's never been viewed as a non-delegation problem. And I'm just wondering, Lisa Heinzeling's comments may be correct that it puts them in an impossible position. But I just wonder, is there any way to still, frankly, educate this court or whatever, frame it, emphasizing more that benchmarking forms of regulation are very much constraining because the agency has to look at what's happening. Because for those in the audience who don't know, the language was the best system of emission reduction adequately demonstrated. And so EPA, whatever it did, it had to show that it was the best system of emission reduction adequately demonstrated, which meant it could have been attacked if it didn't have a basis. And that was a source of constraint. And it wasn't attacked. I mean, that's the important thing. It was never attacked as lacking a basis for what it did based on the best power company operations. So I don't know if others have thoughts about that, but that's a question I have.
Over to you, Professor Heiseling.
I had an observation based on Jonathan Adler's comments, which is the new wine in old bottles point. And I know we've talked about this together before. I guess what occurs to me, why isn't this just a mutant variant of the old desuetude canon, which is the idea that prosecutorial authority, executive authority lapsed if a prosecutor of the executive branch hadn't used it, right? And that canon has been discredited. Even Justice Scalia, in his book Reading Law on Interpreting Statutes, said that his 57th approved interpretive canon was that the desuetude canon didn't exist, right? And now it comes that we're one of the major pillars of the court's major questions doctrine asks, has the agency used this authority in this way before? And that just seems to me, like I say, the desuetude canon rebuilt and kind of amped up for the regulatory setting. And that strikes me as a problem. And one problem is just thinking about, well, when exactly did they lose that power? And also, now it turns out that an agency can't enlarge regulatory power, that we know from West Virginia, but it can shrink it, right? That we know too from West Virginia. And that just illustrates the asymmetry, I think, that exists throughout this. Deregulation, weak regulation, fine. Ambitious regulation, not fine.
Professor Adler, did you want to respond?
Sure. I mean, I'll respond, I guess, to both points. And I mean, first, I should say, I as a legal matter, I think the case reached the right result. As a policy matter, I'm not happy with what that does for climate policy. I would have written a very different opinion. And I will confess that I'm very disappointed with aspects of the opinion, particularly the way some of the text of the statute is not dealt with. But that said, I think on the question of constraints, we're always talking about constraints across different dimensions. And the fact that there is a constraint on one dimension doesn't tell us anything one way or the other about whether or not there's a relevant constraint in another direction. So something needs to be adequately demonstrated. Well, it also needs to consider cost. It also needs to be something that is a best system of emission reduction that, at least as the opinion suggests, is in some way tied to an individual source as opposed to being the best system of emission reduction for, say, reducing emissions from the electricity grid or the power sector as a whole, because these are new source performance or existing source performance standards, not sector standards, not standards for the grid. I would have found the majority opinion more convincing had it engaged the language that supports that, which I think is what it ultimately is saying, more fully. But I think that's part of the way to understand it. We have to be asking about not merely whether there's a constraint, but whether it's a constraint along the relevant dimension. On Lisa's points, I don't view it as an agency loses power it didn't exercise. I think it's rather that the court is expressing skepticism that the power ever existed if it was never used, if no one ever said it was there, if no one gestured to it or suggested it. And if as in a case like this, no one can point to evidence of this power being used in this way existing, or anyone thinking it existed beyond the ability to retrofit an argument for this power in language that was clearly used or clearly written for something else. I think it's fair to argue that seems like a bit of a purposivist interpretive method for a court majority that claims to be textualist and not purposivist. I think that's a fair critique. But I think that's what they're saying. I don't think they're saying you lose the power. I think they're saying you never had it. And I think that's methodologically. I think that's important. I think it's a different concern. And I should just say, does that mean Congress can't enlist the agencies for help? No, but it can. But we have to remember that Congress is the principal. The agency is the agent. If Congress wants to enlist the agency's help, it needs to give it that direction, authorize it to do so, provide that authority. In fact, I think if we think about this case using traditional notions of agency law, old-fashioned agency laws and principal-agent relationships, we can understand what the majority is gesturing towards more fully than thinking about it in other terms. And I'll stop there.
Okay, Kirti?
Yeah, I just want to pick up on something that Jeff said, which is that EPA was probably never going to produce a standard that was based on generation shifting after the Supreme Court stayed the Clean Power Plan. And, I think you don't have to just take his word for it. You can look at the bio that the federal government filed in this case, where it kind of used stayed Supreme Court lawyer language to say basically like that EPA was aware of the stay and would take it into account when it issued its regulation. And I think that's an important point only because it underscores, there's kind of two ways to think about the case. One is a kind of sealed off, was it right? And could it have been written better and all that? And the second way to think about it is the effects it will have on all the relevant actors in the system. And I think the reason that I started with the lack of clarity in the opinion is because I work for an organization that's part of a community that's filled with lawyers who are trying to understand how to deal with this opinion. And, whereas the stay had a deterrent effect on EPA with respect to its new regulation, this opinion is, it's going to affect everything from what people ask the agency to do in their comment letters to what agencies think that they can do to the arguments that people will raise when challenging what agencies end up doing. And so I think that's just I think Jeff's point sort of underscores why clarity in this specific doctrine, as opposed to, a general preference for clarity in the law is particularly important.
So that's great. So one of the first questions, and I wonder if someone might respond to what Kirti said about the potential avenues open to challenging agency actions and how they might challenge them. But on the question, just briefly, before we get to some of the more substantive questions of standing, Professor Busby also mentioned that the barriers for standing were lowered here. And I wonder what the panelists think about what this case says procedurally going forward about the ability of states or others to challenge EPA rules. I know the court didn't say much about the standing doctrine, but nevertheless, some people are reading that now we have a broader standing doctrine here, and it does pave the way for more challenges. Professor Adler and then Busby.
Yeah, so on the jurisdiction, there was, the jurisdictional arguments were raised. I think the court ultimately found them unpersuasive, and I think for good reasons. And I think the Chief Justice only talked about appellate standing briefly, because that's all it took. From the standpoint of well-established appellate standing, there clearly was standing to challenge the adverse judgment the legal effect of which was to disadvantage the parties. And there is no precedent for a stay to eliminate Article 3 jurisdiction. That question was in fact posed at oral argument, and the SG did not have an answer for it, and there's nothing in the briefing on that. On the question of mootness, the dissent, while I'm also not contesting standing, effectively concedes that because of the strictness of the mootness inquiry, this case was not moot either. The Biden administration perhaps could have mooted the case. They didn't, and under traditional standards of mootness, this case was not moot. There's a suggestion that this case was an advisory opinion. There's no precedent cited for that in the dissent. The only case that was mentioned at oral argument for that proposition is an old case called EPA versus Brown, which is quite different from here in that the agency had actually taken substantial steps to change the regulations at issue. Part of them had already been rescinded. The rest were going to be changed because the agency had basically confessed error and it conceded the legal point. And still, Justice Stevens dissented from dismissing that case on advisory opinion grounds. So there's a reason Justice Kagan doesn't cite it in her dissent. She's too careful a justice to have to cite something that would be such a weak authority for that. That said, is there a prudential argument the court should maybe never have taken this? Of course there is. It was very aggressive. But if we're going to ask about prudence, I would throw other things on the table. One, why did the DC Circuit issue this opinion the day before inauguration when it knows there's going to be a change in administration and knows there's going to be a change in policy? Why not wait so that the new Justice Department can say whether or not they want this litigation to proceed and they're going to continue their position or to hold it off? The DC Circuit decided to issue that opinion anyway. I think that was a red flag to the court. I think that was a provocation to the court, whether it should have been or not justifying it, merely describing. I think that's the dynamic. Secondly, why didn't the SG's office, as the SG's office often does in this sort of situation, file a topside brief at the certiorari stage saying, vacate and dismiss, give us a clean slate, get rid of this opinion that injures these parties who will have appellate standing to challenge it, and instead get rid of it and give us a completely clean slate to operate on. They didn't. They instead filed a brief in opposition, and not until the merits brief did they tangentially say, oh yeah, by the way, this is an option. We have no idea what would have happened had the SG taken a different approach. It's possible that might have affected whether the court took the case.
Really interesting point about the timing of the DC Circuit opinion. Professor Busby and then Heinzman.
I guess I'd just say that the problem here is the court being strategic and kind of raising and lowering the hurdles. And so, while this is not a whole panel on standing, that there was a Justice Kavanaugh majority opinion for the court in a case called TransUnion about a year ago. And in the TransUnion case, the majority found that people who were called terrorists were not, that even though Congress had authorized them to bring suit and they were damaged, the court said no. And even Justice Thomas, that was too much for him. He wrote a blistering dissent pointing out the court was essentially second guessing congressional judgments. And so the idea that the court will in one case raise the standing hurdles up and really deny Congress the power to enlist people to bring suits, and then in this case sort of wave them by, I think is a major problem. And so I think what Jonathan said is partly right. I won't fully debate the standing doctrine but the array of doctrines, but at a minimum, there were just many reasons this case is unusual for the court to take and then to get to the merits on.
Mr. Heinzman?
I just want to respond to the court's mood. The idea that the DC Circuit opinion was a provocation. In a previous panel here at Georgetown, before the oral argument, someone suggested that it was disrespectful of the DC Circuit to hold the way it did. And I find that just so striking. I thought it was a completely responsible judicial opinion, came out the day before inauguration, but that makes a difference. Are the justices so delicate that they can't take an incredibly well-argued, thing of sort of interpretive beauty issued on a particular day and actually then judge the case as they would usually judge it. And that just speaks to me about the conservative justices' mood. And I'll just say it, they just seem really angry and distrustful. And I think that's a terrible posture to be in when you're reviewing the government's work.
Okay, I do want to get to the regulatory issues, but so quickly, Professor, you're on mute.
Super quick, I was going to say, I mean, the court may be aggressive, may be in a hurry. Not going to argue that. I know when I clerked on the DC Circuit during a transition year, I know that when you listen to oral arguments about cases involving transitions and so on, it is common for judges to recognize that the sort of change that occurs when you get a new administration is often a reason to delay publication or delay decision because it serves everyone's interest not to necessarily put it out. And to decide, and the DC Circuit, it only issues opinions generally on 2 days. It was a conscious choice to release that opinion the day before the inauguration. And if we're going to ask if it was imprudent for the court to take the case, which again, I think it was, I think that dismissing and vacating would have been a better course. We can also ask, was it prudent for the DC Circuit to issue the opinion when it did, when it knew full well that the new administration was unlikely to be defending the position that the Trump administration took, and it knew full well that a less conservative Supreme Court had stayed the Clean Power Plan before.
Okay, great. So a number of audience questions and are geared toward understanding kind of what's left of the Clean Air Act, particularly Section 111D, but also what the agency can do in the future. And I'm struck by Bill Busby saying that the opinion did major violence to the Clean Air Act, and Jeff Homestead saying that there's no significant impact on how the EPA is going to approach this issue in the future. And then Lisa Heinzling also talking about the choices that Congress now faces after the opinion in applying the major question doctrine. So here's my question about starting first with the section at issue, Section 111D of the Clean Air Act. The majority makes a point of highlighting in the context or in the opinion applying, or the part of the opinion applying the major question doctrine, what it called the gap filler nature of Section 111D. And it emphasized how little the provision has been used over the 40 years of the Act. And posing really this question of how important you think what the EPA has done over the years or not under this section is important. Do you think EPA is on safer ground when it employs sections of the Clean Air Act or other environmental statutes that it has used more often? And if EPA is not necessarily on safer ground with tried and true parts of the Act, what else does EPA need to do to avoid crafting regulations under 111D that run into the major questions doctrine issue? So what's left of 111D? First, let's start there in terms of the agency's ability. Has this opinion done major violence to it, or is it just that the EPA has to regulate more carefully under this section? Bill.
So can I maybe take a first shot at that?
Yeah.
I think Section 111D remains exactly as it has been since 1970. It's a provision that's out there when there are pollutants that are not regulated as either hazardous air pollutants or criteria pollutants. And it's a way for EPA to require states to impose regulations on plants that emit those pollutants in a way that improves their pollution performance, to reduce emissions from those plants. That's what it's meant since 1970. That's the way EPA always interpreted it. If anything, as I said before, I think this decision actually gives maybe more in fact, it certainly gives more flexibility than the Trump EPA thought it had, because it recognized that EPA could potentially do things that were not simply installing pollution controls on a plant, up to and including potentially cap and trade as an effective way to get the installation or reductions at individual plants. and also recognizing that states have flexibility in terms of how they meet the limitations. So the idea that somehow that the court has taken away some important authority that Congress intended to give it, I think is just not true. It has the authority that certainly Congress intended in 1970 when they passed the act.
Okay, I'll come back to the cap and trade point in a minute, but Bill Busby, do you want
So first, I think most of what Jeff said, I agree with. That is, when you figure out how this provision works, why it remains important, why it applies in a particular setting that doesn't come up all the time, but nonetheless has an important role to play. I think all of that's correct. When I said the court does violence to the statute, I meant in the sense when you actually look at what the provision said, how they dealt with them, how they dealt with it, but really the cluster of terms was an egregious example of what our colleague at Georgetown, Vic Nurse, in a new article with Bill Eskridge calls textual gerrymandering. You look at the cluster of words, it's best system, emission reduction, adequately demonstrated. It's saying, look out in the world, see what people are doing and set regulation based on that. And what the court instead does is it kind of puts best to the side, puts emission reduction to the side, doesn't care about what's demonstrated, and focuses on the word system by itself. And then even there, they say, actually, usually the statute deals with technology, and we think they should be looked at as technology too. This provision actually had been in enacted form changed. It earlier said technology, and they changed it to system. And the court just goes right by that too. So as a matter of statutory interpretation, it's abysmal. It's really
but they don't really engage in statutory interpretation other than to say, no, I mean, they say this is a major question. The idea that EPA can establish how much electricity can come from different types of sources, that's a major question. So we look and we say, did Congress clearly intend to give this authority to EPA? There was no reason for them to do a Chevron step one analysis and to look at all the words and how they fit together. I agree they didn't do a great job of that, but that's not what they intended to do.
I guess I disagree, Jeff. I mean, so most importantly, just they go on for about a page and a half talking about the word system and saying, yeah, this is too much, it's a backwater. I can't remember all the different belittling words they use, but they really kind of just say too small a word to do this much. And the reality is, this is a classic area where Congress actually legislated with a lot of care. And frankly, if I were one of the power companies and they were aligned with EPA, and I had invested heavily, what's the best system of emission reduction, the best way we can and are reducing emissions, and offer that up to EPA, or at least with a wink and a nod said we'd be okay with this, which I think is what actually happened with the Clean Power Plan, I think that congressional judgment should have been respected. And so again, I think that the phrase generation shifting was a mistake. I wish EPA had said, we want to base this based on the most flexible, cost-effective ways of achieving reductions, including, if necessary, by trading. That's what they did. I think generation shifting has a sort of connotation of major, massive change, shifting of generations. And I think it was sort of like waving a flag at a bull, a cape at a bull. That's my problem with it. And again, we have to deal with it now, but I do think it's a really poor job of statutory interpretation.
And before I go to Adler and Hageline, I just want to pick up on the cap and trade point in the following sense, right? And trying to understand how narrow or broad this decision is. So clearly EPA cannot use, generation shifting as a basis for setting the standard under 111D. And that leaves the question, what can EPA base the standard on and how much flexibility does it have? For instance, when you think about, cap and trade, the decision mentioned the Bush era clean air mercury rule in the cap and trade program there, which seems to me to be outside of the fence line, but maybe not generation shifting. I just wonder, you can comment on.
Can I,
yes.
as the person who was,
of course, yes,
who was actually involved in developing the clean air trading, the mercury trading rule, the distinction that the court drew is that that program was designed to be a flexible way to get individual companies to install pollution controls that would reduce their emissions. So it was in that context that that the court, and again, to be clear, they didn't uphold that or strike it down. But as someone who's lived with the demise of that rule for 20 years, it was nice to see the majority and the dissent both speak approvingly of the Clean Air Mercury rule. But it was clear that was consistent with their view that this is not about generation shifting. That was about an efficient, cost-effective way to get the installation of pollution controls sort of phased in over time on coal-fired power plants.
Okay, Jonathan Adler, then Lisa Heinzman.
Yeah, a couple of things. I mean, one, I disagree with Bill that the majority doesn't address the revisions to Section 111, footnote 2, talks about the 1977 changes and why they were there. We may disagree with that account, but it's certainly there. On the issue of looking at statutory text in the statute, it's certainly fair to criticize the majority for not engaging more broadly with the rest of the statutory text, but that complaint applies to the dissent as well. The dissent, in fact, says repeatedly that the phrase best system of emission reduction by itself is enough to resolve the case, and says that we can take that text, look at it in isolation, out of context, without reference to other provisions, including the title of the section and so on, which at least raise a suggestion that we might be talking about source-specific controls as the basis for setting the standard, and doesn't even address those concerns. Now, those concerns might not ultimately be dispositive. They may not ultimately carry the day, but given Justice Kagan's complaints about textualism elsewhere in her opinion, and given her arguments in prior cases about how you need to look at the whole text, it was quite shocking to me to see the dissent do what the majority was perhaps also guilty of, which is be laser focused on one phrase in isolation without even engaging with references to source and source specific aspects of the program as something that at least needs to be contended with. In terms of what this means going forward, I agree with Jeff that I think the line the court was trying to draw, I don't think it drew it as cleanly or clearly as it did, perhaps because of time at the end of the term, perhaps because they realized they don't know this area of law as well as they would like to and didn't want to screw up the Clean Air Act, was to say you're not going to use something like generation shifting in setting the standard, but we're not going to say anything that would preclude generation shifting or other sorts of trading as a compliance mechanism, which I know was one of the things the power sector was really concerned about. And I can't remember one of the petitioner's briefs, if I recall correctly, wanted the court to take both off the table. And that would have been a very big deal. What I think the question is going forward on Section 111 is, can EPA come back and say co-firing or CCS, carbon capture and sequestration, either or both of those are adequately demonstrated, considering cost, and use that as the basis for a new standard? There's nothing in this opinion that would preclude that. I think it would be, wouldn't want to prejudge what the outcome would be on the arguments about adequate demonstration and cost. I suspect the big argument would be over the cost side, at least with carbon capture. But I think there is some room there, and I would think the EPA would focus on that. Last thing I'll say, which I think EPA should be worried about, not so much from what's in the opinion, but what we saw at oral argument, both in this case and in the COVID case. Policies that look like the agency is doing one thing, but is doing it for the reason of reducing greenhouse gas emissions. So, for example, if the EPA plans to tighten, say, the particulate NAAQS standards, which it clearly has the authority to do, If I'm a lawyer in the EPA General Counsel's office, I am scrubbing every document, every speech, every talking point to make sure that any climate benefits are ancillary, secondary, and oh, yes, we get them too, and not to say anything that suggests that that's the reason for the policy. I think the Chief Justice in particular has made clear, and this was very evident in the COVID case, that sort of, I have the power to do A, but I'm doing it for reason B, is something that he is very suspicious of. And I think this decision reinforces that. And I think EPA has to be careful about that, how it deals with things like climate co-benefits, if it's going to use other mechanisms to reduce greenhouse gases while it's also reducing traditional pollutants.
Lisa Heinzman?
Yeah, I was just wanted to address actually the last point that Jonathan made, which was the question I think that you asked Sheila partly about whether they should be using tried and true regulatory methods. I think that's right at this point. We're almost 2 years into this administration. How many more blockbuster rules are they actually going to get out in the last 2 years? I think they should focus on things that can drastically affect coal, but not because of climate change. So NEX for particulate matter and ozone, rules on coal ash, rules on toxic emissions from coal-fired power plants. All those are really powerful environmental tools that aren't directly aimed at climate. And I think Jonathan is exactly correct, but I would say, and I'm sad about it in the sense that the court is looking weirdly at statements from the agency head, testimony from the agency head, White House press documents. And if they're at all like braggy or at all talk about climate change, it doesn't like that. So just notice the moment we're in. So yeah, I agree. Legally speaking, they're on firmest ground right now if they hit the stuff that they've always done, and they can do that and get a large climate payoff, I think, for it. But they can't say it. So the Supreme Court conscripts us in a silence and almost a denialism about climate, the climate threat, about the powers to address it, ancillary to other problems. And I find that really troubling. I think as a lawyer, I'd probably say what Jonathan is saying, but I think it's a terrible situation to be in when the court effectively is saying, if we see this from you in a press release and testimony anyway, then that's going to be a reason for us to reject what you're doing.
Okay, Kirti.
Yeah, I think I'll just say two things. So one is that I'm not quite sure it's fair to the dissent to criticize the dissent for not going from A to Z with its statutory interpretation, because I think the only point the dissent was trying to make is that if we're doing textualism as, I understand it to work, understanding the word system, reading it in the context of other parts of the Clean Air Act, et cetera, gets you to at least a really serious question about whether this is, authorizing EPA to do what it did. And at some point, when you're writing a dissent just as a practical matter, it doesn't make sense to respond to arguments that aren't anywhere addressed in the majority. So I don't disagree with Professor Adler's point that, the dissent could have, run the table on these arguments, or maybe run the table isn't a phrase he would agree with, but at least addressed all the arguments that are on the table. But I'm not sure it's necessary or that it's an indictment of the dissent in any way. The other thing I would say is that I do think some of the reporting about this case might be overreading the majority, or at least maybe I might be overreacting to it, which is that the majority does say that it, doesn't have any occasion to address the full scope of EPA's authority under the Act, precisely because it's not really engaging in interpreting the text in this opinion. But it also has other statements in the footnotes, like footnote 3, I think, for example, says, in responding to the dissent's reference to fuel switching, which is not, it's sort of maybe one step beyond co-firing, but isn't at the source often says EPA has never tried to do that and I doubt that it could. And it's not clear to me whether that's a textual reason, there's some textual reason behind that, or whether that's an arbitrary and capricious argument that it would work. And there is really that disagreement between the majority and the dissent over whether fuel switching is on the table. And so I do think there are hints in the majority that, this isn't the end. This isn't the only thing it's carving out. And I would just point out again that two members of the court, not a full majority, but Justice Gorsuch and Justice Alito, would have the major question doctrine be triggered by effects, not by approach, right? They're, non-exclusive list of factors is things like how significant it is, how robust the political response is. And those can be triggered by a really robust regulation, even if it is just a very traditional approach to that regulation itself. So I just don't know that we have all the answers for this opinion.
So, Kirti, let me follow up with you on the last thing you said just for a sec. One of our audience members asked, could someone take a moment to list the 7-part major questions doctrine test referenced by Kirti in her remarks? Is this 7-part test generally accepted to be the test, or is this evolving? You talked about the failure to really clarify this doctrine in the opinion. So can you speak to this?
Yeah, I certainly don't want to be on the record, nor would I think my employer want me to be on the record as saying this is the test for the major questions doctrine. All I was doing was counting the things that were in the majority's opinions, discussion of why this is a major questions case, and those included things like this is a long extant provision, so I guess it's been on the books for a while. It's a transformative expansion of the agency's authority. The language is vague. It's an ancillary provision. It's a gap-filling provision. It's been rarely used in decades, and that Congress has attempted to do something similar but failed to pass legislation to that effect. There might be more. There might make those overlap. I don't know what the right number is, but all of those are in the section that the court uses to describe why it's sort of obvious why this is a major questions case to the majority.
Okay, and before we leave this topic, I'll come back to the implications for regulating carbon and other greenhouse gases. But just on the audience questions, someone asked how this decision affects the Chevron 2-part test and what's left of Chevron deference after the decision. Anyone want to address that, Lisa?
I think it was clear before this decision. I think it's even clearer with it. I do think Chevron is dead. It's simply dead. It's become an obscenity that neither the conservative justices nor the liberal justices will even speak. They cannot say Chevron's name. The United States government has stopped in many cases asking for deference. There were other statutory interpretation cases this term that were less consequential, perhaps, certainly less well-known, where the court had every opportunity to mention Chevron. It didn't. It even spoke in terms like, we don't agree. This is a case called Marietta Hospital. We don't agree with the agency's interpretation. And that was enough to reject it. Not mentioning Chevron and also stating a test for what means that an agency's interpretation fails. That is way out of line with Chevron. I'll just note too, if I can just note something, I think it is done. The Supreme Court hasn't deferred since 2016 under Chevron, right? I think it is just done. And we've all been complicit in it because nobody wants to mention Chevron because it's like the climate denialism we're all conscripted in. We cannot mention Chevron because that'll kill our case. But I think it's dead. And it's just worth mentioning just for the audience, Chevron was a case effectively about a kind of market trading program, an incredibly consequential decision made by the EPA to allow kind of bubbling of sources, stationary sources involving power plants. It's sort of incredible to just put the two side by side. And in one, the court was motivated to say, wow, the statute's complicated, let's go with the agency. And the other, this is such an important question that even Congress really can't authorize it. And it's just incredible what a distance we've come. But if you find yourself asking about Chevron, I think you might just remind yourself, I think it's dead. The Supreme Court just hasn't officially issued a death certificate.
And to be clear, it was not cited in this case, right? Chevron was not cited. Chevron was not cited. And
the agency didn't ask for it, didn't mention it in that way.
Can I weigh in and just say you will not be surprised to know that I disagree with Lisa's view on this. I think it's pretty clear that this is an initial inquiry that comes before Chevron, that this is a question that's asked before you get to Chevron step one. Exactly the idea that there has to be a clear statement is different from the kind of analysis that has typically been done. I think the Chevron approach has been a useful way to look at regulations, and I think the DC Circuit will continue to look at it that way. I think other courts I think this is an additional gloss onto Chevron. I think there is a sense in the conservative legal community, including with the justices, that Chevron deference has gone too far, that it's been used essentially to say, as long as an agency can come up with a plausible interpretation of the statute that lets it do what it wants to do, we'll defer to that. And so I think it is correct to say that there are probably people on the court who think it's gone too far, but I think the basic construct is still there.
Okay.
So I think it might surprise people to know that I also disagree with Lisa about this, but just for maybe I'll add a gloss onto it, which is I agree that it's unlikely the Supreme Court will use Chevron in the future, but I do think the doctrine, as somebody who reads, in theory, most of the courts of appeals opinions on ad law and environmental law, I do think the doctrine is still alive in the courts of appeals and particularly in the lower courts. And I think, without psychoanalyzing the justices, one reason for their reluctance to overrule it entirely might be to protect their own docket and to allow for some, stability in the interpretation of regulations and statutes in the lower courts. But I think none of that takes away from a point that Lisa made earlier, which is that when that rule doesn't hold, when the major questions doctrine does apply, those are going to be, likely the, really pressing, emerging exigent problems. And, people can disagree, but I share Lisa's view that that's the situation where you least want to kind of load the dice, put a thumb on the scale, however you want to put it, against the agency even having the ability to address the question versus the question of whether Chevron does or doesn't apply, which just leads the court to neutrally ask whether the statute authorizes the agency action, sometimes upholding it like in King, sometimes not like in other cases.
So when I'll make a gap filler comment and then 2 points that relate to this. So one is, I just want to expand a little bit on something that Lisa Heinzerling said. The court has for years basically asked agencies to look more broadly at the costs and benefits of actions they've taken and had favored flexible strategies. And so you look at some of the major precedents, you look at the Homer case, the UARG case, the Chevron case itself, she said, Michigan versus EPA. All of these cases seem to be going in a direction that was sort of agencies look, don't be blinded. Think about the overall logic and repercussions of what you're doing. Don't just look at one thing. Here, it's the opposite. So what I find really striking and distressing about this case, among other things, is that what the court does is it really looks almost exclusively at the burdens related to the regulation. And basically, if you read the majority, it's very hard to figure out why would EPA have bothered to do this, other than mentioning climate at the front. They don't really talk about this being a major important regulation with lots of benefits. So that kind of inversion of the approach is, I think, odd, and I find it really puzzling, frankly. And then the other two big questions I have is, what about Chevron, as the person asked? So one is, Chevron is not the only form of deference, right? And so I view a really big question is when an agency wraps up its action much more in deference to its expert scientific judgments applied in an area where they know a whole regulatory regime and an industry and the like, that's historically, long before Chevron, been an area for maximal discretion or deference given to agencies to wield their expert discretion. And I think that still applies. Now, Gorsuch, he likes this phrase, they can fill in the details. Like that's the phrase he's used in a few of these cases. And so I just think I think agencies wisely now will emphasize much more the empirical groundings of what they do, not play word games, but try to say, here's what we're doing and why. And I think basically what my view is that Chevron is, as Lisa said, no, everyone's scared to cite it because you don't want to lose votes. On the other hand, the Kaiser case, Skidmore case, I think we might be moving towards a unified deference regime, which is saying agencies, if you want to have a prayer for deference, be really thorough, really explain yourself, really engage the facts and the science, and maybe the courts will realize you're acting in a realm where you know more. I think that's still possible. I just don't view it as something where the court, at least the Supreme Court, will be citing Chevron in that setting. But that's always been more in the State Farm arbitrary and capricious side. But so I think we're going to see Kaiser, Mead, Skidmore deference as the norm now.
Okay, so that's very interesting. Thanks, Bill. We have a few minutes left, and I want to kind of aggregate the remaining audience questions I want to ask. And most of them go to the future of the regulatory climate change agenda. And so let me ask this in 3 parts and think about which you want to respond to, and then we'll do a last lightning round. One is, what does the decision mean for EPA's ability to regulate carbon emissions from existing power plants? We've talked about carbon capture, fuel switching. What does it mean? What advice would you give to the EPA about what they can still do? Second is, what about the avenues that the EPA or other agencies, I think Jeff mentioned FERC and SEC, what are the avenues that EPA or other agencies have to achieve their climate agenda? The questioner wonders about the role of the Toxic Substances Control Act, other provisions of the Clean Air Act. Could EPA go the NAAQS route? And someone's already talked about that. So what about the regulatory climate agenda under other acts or even other agencies? And lastly, at least Jeff mentioned but also others, the EPA's authority to regulate transportation emissions remains strong. And this question asks whether that means that regulation of transportation emissions has to carry more of the weight going forward of the climate agenda. And lastly, someone asked about what will the DC Circuit do on remand. So let me just do a lightning round in order of speakers to see just if you could pick one of those to answer. We don't have time for you to answer all of them. Adler?
So, I mean, EPA has authority, but it's limited. It can use, across the board, I would say EPA can use those authorities to address greenhouse gases so long as it is using those authorities in the way those authorities have traditionally been used. And that where EPA, and for that matter, other agencies are going to get in trouble is where they're, to overuse my analogy from earlier, using a wrench like a hammer. They've been given a bunch of wrenches. They can use them as wrenches. Unfortunately, unless and until Congress acts, some of those wrenches aren't very useful for greenhouse gas emissions. And that really puts an onus on Congress, which none of us are overly optimistic will be very active in this area.
Yeah.
So first, I agree that anything that the agency does, they're going to wrap up with continuity claims, that whatever they're doing under other provisions is like what they've done before. And then, as everyone has said, if they're regulating other pollutants that have climate effects or other problems, that should still be okay and could be very important as far as results. As far as part of your question in the middle there, Professor Foster, you relayed to us was, what would you say EPA should do? My sense is this court, not just this opinion, these justices, they don't quite get data, they don't get statistics, they're not versed in science. If I were EPA, whatever they do, I would, in both a technical appendix, but then in the Federal Register, I would use anecdotes with some detail about whatever is being done, particular examples of what people are doing that makes it the best and why it's established and why it works. In other words, I would really make particular instances in a very tangible storytelling way clear why it's chosen. Because I think in the Clean Power Plan, I think had a lot to be said for the materials put together. And the one problem with it, as it didn't have a strong narrative form, it was kind of hard at times to find why they did particular things. And so I would just make really clear, this is what we're doing. This is why. You look at this kind of facility or this kind of plant or this technology. This is how and why it works and why it satisfies the test. I think that will help.
Great. Thank you. Kirti?
Sure. I think what I'll say is to emphasize a point Lisa made earlier, which is that this administration has 2 years left. And so I think what it's going to need to do, which I took to be Lisa's implication, is balance what are the most effective regulatory tools to address climate change against the litigation risk associated with, its preferred approaches. And it'll probably roll out whatever the right combination of those are. And it's sort of hard to talk about those in the abstract, but I assume that's the calculation going on in various agency general counsel's offices. And I guess it's also worth mentioning that, one questioner asked about the transportation emissions, that is the largest source of our emissions. And I think it's worth noting that even before this decision came out, after the shadow docket stay opinions in the vaccine mandate case and the eviction moratorium case, the challenge to EPA's regulation of greenhouse gas emissions from motor vehicles, the very first issue listed in that challenge is whether it violates the major questions doctrine, I guess, to consider things like electric vehicles, even though the first regulation did just that. So I think that's just an example of how, even if, that's not a ultimately successful argument, it's gumming up the works on, these important types of regulations.
Great, thank you. Lisa?
I have a remark about the remand to the DC Circuit, which might be mischievous, but is kind of serious, which is that the Supreme Court actually didn't answer the question posed by the case, in the sense that the EPA had said during the Trump administration, we can only do measures that are available at or to the source, within the fence line of the source, applied at a single power plant. And that's why we have to repeal the Clean Power Plan. And that's why we're going with the specific weakened, very weak rule that we chose. And that's what the DC Circuit struck down. So the DC Circuit on remand could say, actually, the Supreme Court didn't answer the question we answered, didn't answer the same question we answered. So let's hand it back to EPA. We still think that the ACE rule is invalid because it answered the question in a way the Supreme Court didn't answer. And the repeal was built on a more robust view about the limits on EPA's authority than the Supreme Court embraced. And so let's just hold everything as it is. No ACE rule, no Clean Power Plan. Send it back to the EPA. And then you know what the EPA could do? Nothing. Right? And remember that regulation under Section 111 is, at least according to American Electric Power, decided in the Supreme Court not that many years ago, is the only thing stopping suits based on federal common law from taking place. Right? And so there could be one solution to all this. Let the common law blossom. Right? Because nothing important is happening right now under Section 111. Let it come back.
And there are percolating public nuisance cases to that point. Okay. Jeff, you have the last word.
Yeah, I think there's some problems with Lisa's mischievous suggestion, but I won't get into those. I want to talk, I think, about your second question. I was struck by the way the question was posed. What's going to happen to other agencies and their climate agendas? It just seems odd to me to think that every agency has to have a climate agenda. I don't know that that Congress intended SEC to have a climate agenda, or the Department of Health and Human Services to have a climate agenda.
Actually, that was my flourish on the question. The question was actually, what are the other possibilities for EPA, and particularly under TSCA and the Clean Air Act? I pivoted to your comments about the SEC.
Yeah. So all I would say is there are plausible textual arguments that EPA could regulate CO2 emissions under TSCA. They could regulate it as a hazardous air pollutant. They could regulate it as a criteria air pollutant. They could regulate it as an ozone-depleting substances. Those theories are all out there. And I think the court has foreclosed those because it's pretty clear that they've never been used that way. That's not the way Congress intended them to be used. And I think that's a helpful thing, that we're not going to spend the next number of years debating over these provisions that were never intended to deal with climate change. And I'm hopeful that the many people on both sides of this issue who would like to see something done, this may actually force people to have conversations and make compromises in Congress that could get us to climate change legislation. So I'm optimistic. I won't say in the near term, but over the medium term, I think this will be a healthy thing for meaningful climate change in Congress.
I love ending on optimism. Thank you for that. Over to Kate, Keep Up Alive. Thank you to our fabulous panelists. This was really wonderful and clarifying. Kate.
Thank you, Sheila. I want to emphasize and echo your thanks first to the panel for their really helpful and interesting insights on the decision. And thank you, Professor Foster, for your skillful moderation of the conversation. And thank you to the audience for being with us today. We will post the recording of the webinar on our website and in the coming days, so folks can turn back and take another look. And I hope you all have a wonderful rest of your day and your week, and really appreciate your joining us. Thank you all.
Thanks.